right, let's go ahead and turn this over to Jeff and get started. Jeff, you should have control.
Thank you, Amy, and thank you all for taking time today to join us. My name's Jeff Lester. I'm a financial advisor at Eide Bailly through Eide Bailly Financial Services, and I really specialize in helping our business clients with 401k plans and with some other kinds of plans like defined benefit cash balance plans, primarily to focus on trying to help them save money on taxes by using retirement plans as a really valuable tool, and then also as a valuable benefit to them and their employees. So today we're going to talk about a couple of things. Was originally going to be a presentation on the Secure Act, but then in February along came something called COVID-19. So we're going to cover a little bit of both of those. I'm going to get disclosures out of the way at the front end, give you a second to see the disclosure page. And I want to give some acknowledgments. There's so much information out there on the Secure Act and of course on the CARES Act. And we gleaned our information from multiple sources, but especially a lot of info we got from the Internal Revenue Service and then various record-keeping firms such as John Hancock, Alaris, Epic, Voya, all that you will see information interspersed with ours that we got from them and through our joint efforts with them in helping plan clients. So a lot of sources for information today and a whole lot to try to digest. So what we're going to do today is we're going to cover the CARES Act, of course. Then we're going to move on to the Secure Act. And the CARES Act, we're really, because there's such an immense amount of information out there and activity right now, we're just going to hit a couple of highlights that are kind of timely. And we're going to move into the Secure Act because the Secure Act covers a lot of ground. The Secure Act is probably the single biggest piece of retirement plan related legislation since really since the Pension Protection Act about 15 years ago. So there's a lot of ground to cover, and I want to try to give as much attention as we can to the Secure Act. So quickly on the CARES Act. CARES Act allows participant withdrawals of up to $100,000 from a retirement plan or IRA, and that's assuming that the participant or IRA owner has a coronavirus-related need for that distribution. Also waives that early withdrawal penalty of 10%. Withdrawal cannot, of course, exceed the vested balance. I've actually had people ask if they can take out somehow if the rule allows them to take out more than their balance, and it does not. So it applies to distributions between January 1 and December 31 of this year. Participants have to meet one of the requirements, and they get to self-certify. So you as plan sponsor are not responsible for whether they are being 100% truthful or not. However, if you know that they are not, it's your obligation to tell them that. But a participant has to be either diagnosed with COVID-19, their spouse or dependent has to be diagnosed, or they have to have experienced adverse financial consequences. And this part starts getting into a little bit of a gray area, but if you look at it, you have to have been quarantined, furloughed, laid off, have work hours reduced, haven't been able to get child care, which prevented you from working, all because of COVID-19, or your business is closed or your business hours have been drastically reduced, and that's for business owners. And a lot of people, this does legitimately fit. It fits a lot of circumstances a lot of people are going through, but just be aware that if your participants ask for a COVID distribution, you want to make them aware of what the criteria are. And of course, item number 4, the Treasury Secretary could come along at any point and offer additional guidance that would make it even more broad than that. One thing I meant to say at the very beginning, and I'll go ahead and say it now since I've already started offering some opinion, is that the opinions I express today are my own and mine alone and don't necessarily represent Eide Bailly or Eide Bailly Financial Services. So I will provide you with some of my opinions as we go through some of the material today to try to give you a little bit of a flavor for what I interpret the rules to mean. So CARES Act hardship distributions plan can rely on a participant's self-certification, as I mentioned, still limited to 100,000 that you can take out. Taxes, though, can be spread out over 3 years. So participants have a choice of paying the taxes at the front end all at once in 2020, or of waiting until the government provides a form. So the IRS says that by the time next tax season rolls around, they'll have a special form you can use to spread the tax over a 3-year period, 2020, 21, and 22. But the form doesn't yet exist. So right now, your only choice is, do I withhold all of it now or none of it on the tax withholding? And so again, that's one of many areas you're going to hear me mention today where we're still waiting for additional guidance. CARES Act loans. So you can first of all delay the loan repayment if you take a CARES Act loan. The repayments must be appropriately adjusted. So let's say somebody takes a loan now for the CARES Act, they can put that loan off until next year, but at the time that you're going to actually start those loan repayments, your third-party administrator is going to have to re-amortize the payment schedule for you. So that's something to be aware of. We'll get to our first poll question. So has your business or organization processed any CARES Act related distributions or loans for participants in your retirement plan? Interesting. So only about 7% have, and that would really be consistent with my experience as an advisor on plans. It's really been a relatively small number of plans and of plan sponsors who have asked to set it up to where they could process COVID distributions of any kind. So waiver of 2020 required minimum distributions, of course, that waiver waives those for the calendar year 2020 for defined contribution plans, 401ks, 403bs, etc. Allows participants to keep the money in the plan instead of taking those mandatory distributions. Also allows for special rules regarding the waiver period to hold harmless plan sponsors and plans for taking advantage of that waiver. So I think we're going to probably see some more guidance in hindsight on how those RMDs are handled, especially as it applies to people who may have taken RMDs out prior to the time that COVID really hit the news, and prior to the CARES Act actually as well. So funding relief for certain defined benefit plans under the CARES Act allows a single employer DB plan more time to meet their funding obligations. So in other words, if you had funding obligations due in 2020, you can actually delay them all the way up to January of 2021. So at the time that those are due, though, keep in mind that any interest charges to those contributions would accrue all the way to the date that you actually pay them. So they allow you to make those payments for employer funding later, but you still have to apply an interest rate adjustment to that. I want to point to this note at the bottom of this screen. If you or your business, if you sponsor a plan and you think that your defined benefit plan, that this issue might apply to you, that you might want to delay it or have that interest accrual that you would have to pay as a result of delaying it, you need to contact your actuary for your defined benefit plan and talk to them about your specific case. Don't guess, don't take for good what you read on the internet. Reach out to your plan's actuary and get very specific guidance on your plan. That's the only prudent way to do it. Now we've covered a few highlights on the CARES Act. I want to jump into the Secure Act. Again, I said this is probably the most landmark retirement plan legislation since the Pension Protection Act, signed just last December, and it'll have an impact on, specifically on defined contribution plans, on DB plans, on IRAs, other related things. Let's start with RMD rule changes. So the first thing it does is increases the RMD age, required minimum distribution mandatory age, from 70 and a half to 72. So that's effective for RMDs made after December 31 of 2019, and specifically with regard to individuals who turned 70 and a half after that date. So here's the key. For you to claim an age 72 RMD date, you have to have been born on or after July 1, 1949. If you were born before that, you're still stuck with 70 and a half as your starting date. However, this is complicated by the fact that you don't even have to take an RMD in 2020 because of COVID-19. So, best thing to do is, regardless whether you take a distribution this year or not, is remember, for you to take advantage of that age 72 RMD, you have to have been born after July 1, 1949. So individuals who are age 70 and a half or older now can also start making contributions to an IRA. The old rules only allowed you to make contributions to a Roth IRA, and of course that's all subject to you having earned income to do it with. You have to have enough earned income to make the contributions. But previously, if you had enough earned income, you could contribute to a Roth. Now you can contribute to a traditional IRA if you are over 70 and a half and have the income. And by the way, the amount allowed for qualified charitable distributions, if you do that, would be reduced by the amount of any IRA contributions you make if you are past 70 and a half. So you've got to weigh both sides of that. If you want to make charitable contributions, or charitable distributions rather, it's going to be offset by any contributions you put into your IRA. So just think through that carefully before you make your decision, and that's already in effect for the year 2020. Designated beneficiaries other than a non-person of a DC plan participant or IRA owner has 10 years to receive the full distribution. So it used to be that you could stretch IRAs, inherited IRAs, no longer. So if you have a designated beneficiary that's not a person, so it could be a trust or an entity or something, the owner has to do that within 10 years. I say other than a non-person, keep this in mind, other than a non-person. So this doesn't apply the same to non-person entities as it does to people. So if you are a designated beneficiary, you as a person, you now only have 10 years after the death of the decedent for you to take that full distribution. You can't stretch it. There are, of course, exceptions. There are always exceptions. So if you're the surviving spouse, if you're a minor child and you're subject to a 10-year rule after you become majority age, so when the child becomes an adult, the 10-year clock starts ticking. If you're disabled, it doesn't apply to you. Chronically ill people or persons who are not more than 10 years younger than the deceased account owner. So there are a few caveats, but for most people, if these criteria don't fit you, your stretch IRA has been reduced and now you've got to take it within 10 years. So when I mention non-person beneficiaries, so that would be charities, estates, trusts, etc., are subject to a 5-year rule. So if you have an entity that receives your proceeds from your IRA or your qualified plan, that's an even shorter period of time before they have to take the assets. So now let's look at another huge area. This is one that I think is going to slip up on people, and that's expanded employee coverage, meaning an expanded group of employees you're going to have to include in your plan down the road. So this is probably the most important page in the whole presentation, in my opinion, as a result of this new rule, and that's because 401k plans have to allow their employees to start making 401k contributions. That means salary deferral. That's what 401k is. Have to allow you to make salary deferral contributions if those participants have obtained age 21 worked at least 500 hours in 3 consecutive 12-month periods. Okay, so we're going to start wrapping our arms around this. And by the way, this doesn't apply to collectively bargained plans. So collectively bargained union or trade association type plans operate under a different set of rules. So employers not required to make non-elective contributions for these workers or to match their contributions. So that means even though this new pool of employees is going to become eligible to put their own money in, you're not going to be required to make non-elective contributions or to match them. The only thing you're going to have to do is allow them to put their own money into the plan, at least as far as all the guidance and rules that we know of show us at this point. Employers can also exclude these employees from their non-discrimination testing, coverage requirements, top-heavy testing, minimum benefits, etc. So how does all this work? Down in red here, I say effective for plan years beginning after December 31, 2020. So that's after the end of this year. It will apply to service during any 12-month period beginning prior to 2021 is disregarded. So 2021 is when the clock starts running. Service prior to 2021 is disregarded. Okay? So starting on January 1, 2021, if you have someone working for you that's part-time, they only work 500 hours in a year, but they do that 500 or more hours in a year for 3 years. So they do that in 2021, 2022, 2023. They've done it at that point for 3 consecutive 12-month periods. Then in 2024, you have to include them in your plan. So it's not like this is something that's going to happen overnight. But I want you to be aware that the train is already coming down the track. So again, service for any 12-month period prior to 2021 is disregarded. But starting in 2021, the clock starts running. It's really not a big deal because all you're doing is allowing those employees to put their own money into the plan, and that's a good thing. The whole purpose for this rule is to allow more people to put their own money into retirement benefits, which will eventually take a burden off Social Security. So, poll question number 2, prior today, was your business or organization aware that, as we just discussed, 401k plans will be required to allow qualifying part-time employees to make salary deferral beginning in 2024? Okay, I kind of expected that, and that's one reason I made a big deal out of it. And so I just want you to be aware the clock starts in 2021. And again, I don't consider that to be a bad thing. I consider it to be a good thing. You're going to get to include more of your people in plans, and it really won't cost you anything extra as a business owner or an organization because they're putting their own money in. That's the whole purpose for that change. Another area is pooled employer plans, which are sometimes called PEPs, or you've heard of MEPS, multiple employer plans. Maybe you have, maybe you haven't. This is an area I'm going to give a little more of my own opinion on. So employers with no business or industry relationship may now, under the new rule, participate in pooled employer plans or MEPS or open MEPS together. In other words, businesses that have no affiliation, no common ownership, can get together and decide, hey, let's have a 401k plan together instead of each business having its own plan. Now, there are a lot of strings attached, and this is where I'm going to start giving you some opinion. So participating employers are going to be required to use a pooled plan provider, and that pooled plan provider must act as a 316 plan administrator. In simple terms, what that means is instead of you as the business owner being really your own 316 administrator, instead of the buck stopping with you, you're going to relinquish that control to the administrator for the plan to make decisions, to make any number of decisions about plan design, investments, all sorts of things that could affect the plan. So what you'll be doing is relinquishing some control if you go into that kind of arrangement. The trustee of that plan, which could be you as a business owner or as the business owner of the primary plan that's the sponsor plan that everyone else is joining, would be responsible for collecting employer contributions and for making sure that all the testing gets done and all the mandatory filings and so forth. So this all kicks in effective after December 31 of this year. It's something new that kicks in for 2021. However, it's kind of complicated. It sounds on the surface like, oh, this could be a great idea. We can pool our plans, it'll cost less, we'll still be able to do the same thing, but you relinquish so much control that in my experience as an advisor, and I have been advising on retirement plans for 12 or 13 years now, and in my experience, it's actually more beneficial to most small business owners to have your own plan. The tax advantages and the control and the plan design options are so much better with your own plan than if you pool together with someone else and relinquish a lot of control. But let's look at some of the considerations. Some advantages of doing this would be there's one plan document, no matter how many employers participate. But the pooled plan provider is going to be able to limit the plan design and investment choices. So you may not get to pick. There'll be one Form 5500 to file annually. So if it's a plan that meets the large plan status criteria, meaning in excess of 100 employees, there'd be one plan audit in that case. But small plans may lose their exemption from independent audit requirements. And so you might have 10 employees and there might be 10 other businesses that have 10, 15, 20 employees each. And any one of those employers with their own plan would be considered a small plan, would not have to have an annual audit. But if you pool together and you do a PEP or a MEP and your number of collective employees goes past the 100 threshold as described in the rules, you may suddenly be part of an annual plan audit. So the government gives on the one hand and then sort of, in my opinion, takes away on the other, which makes this not nearly as attractive. You do get to share administrative costs, but your share may be more, it may cost more than a single plan would because of other aspects of the multi-employer plan. PPP or that plan provider must serve as a 316 administrator. I mentioned that on the previous screen. The buck will stop with that administrator. And so it stops with that person. That person has control instead of you. Each employer will still have to provide their necessary information, census data, compliant questionnaire, all the other related info. You don't get off the hook on any of that. Still have to do all that work. So again, it's more complicated and in my opinion doesn't do a whole lot for most employees or for most employers. The provider is responsible for giving employers required disclosure and notices, and then each employer is responsible for distributing it to their participants. Still have that notice requirement. And then certain fiduciary responsibilities are shifted up to that controlling party, that 316 party. However, there's still a duty to select and monitor them by each of the participating employers. So you really, in my opinion, don't gain much. As a matter of fact, I've talked to a few plans that previously got into MEPS within the last, let's say, 5 years, and wish they hadn't because they relinquished so much control and they were at the effect of rules that other people had created, and they felt like they really gave up a lot more than they gained. Again, that's just my opinion. Safe harbor plan changes. So this is something that's helpful. It eliminates the annual safe harbor notice requirement for plans seeking to fulfill that safe harbor through the 3% safe harbor non-elective contribution. So two ways to do safe harbor. You can do it as a non-elective, meaning everyone in your plan who becomes eligible gets a safe harbor a contribution from the employer, from the business or the entity. Or you can do it as a safe harbor match. So if you do it as the safe harbor non-elective, you're no longer going to be required to distribute that annual notice. If you do it as a match, you're going to continue to have to distribute that annual notice that most plans distribute around Thanksgiving of each year. Does it really save an employer a whole lot of effort? I don't know. I think it kind of depends, because anymore the rules allow, if you have email within your organization that is at an organizational level, everyone has email, you can send those notices electronically. And there are other ways to provide them too. So I don't know that it really helps that much. But if you have that non-elective type contribution in your plan, you will receive notice from your provider that says you don't have to send that notice anymore. Should reduce the administrative burden. Again, I think it's questionable how much, but that's already in effect for 2020. So we'll find out in November how most of the providers let their plan sponsors know about that notice requirement. So auto escalation cap increase, this is a change. So in the past, if you set up your plan with an automatic contribution arrangement, meaning employees could automatically come into the plan at a certain deferral percentage, and then it could have an auto escalation feature on it that allowed their deferral to get bumped up, say 1% per year each year. It's a real good tool. It helps people save more money in their plans because most participants don't notice an increase of 1% from one year to the next going into their plan out of their salary deferral. In the past, the cap on that was 10%. When someone got bumped up year after year and they finally reached 10%, that was all that your plan could require, is for it to stop at 10%. But they've changed it now to where it can auto escalate all the way up to 15%. I believe that really will indeed have an impact and will allow some people to save a lot more into their plans, especially maybe people in that over 50 category where they become empty nesters and they can afford to have more going in, and they will probably allow that escalation to continue maybe all the way to 15%. So it does improve savings opportunities, at least for some people. Poll question number 3. Which of the following features is already a part of your business or organization's 401k plan? So name several things here: safe harbor, automatic contribution arrangement, automatic increase that allows employees to increase the contribution amount each year to automatically select that, some combination of those top 3, or maybe none of the above. I'm looking at the numbers here. I'm very intrigued at the numbers, and I appreciate all of you voting in the polls, by the way. So 40% of the plans have at least some combination of those features, and that's awesome. Those are all features that, in my opinion, as an advisor on a lot of plans, are really powerful features for you to use to try to improve the amount of money your employees are saving for their own retirement. They're great tools. And so if you have questions about those in your own plan, you should go to your plan provider, to your advisor, or your third-party administrator, probably third-party administrators where you're going to get more details on that, and ask them, how do I add any of those features to my plan, and how would it work? Because those are really great features. There are some things coming down the road, lifetime income considerations, that are a little unusual for the way most plans are set up anymore. So think of lifetime income as being an annuity calculation to include the possibility of really including annuities in plans as an investment option. So what this new rule does is it says at least annually, defined contribution plan benefit statements, meaning on your participant statement that you get, most people get statements quarterly, on at least one statement per year, the provider should give you an income calculation, a lifetime income disclosure, and a calculation. And we've seen this already get added to a lot of plan statements. Looking across all the record-keeping platforms, I'd say in one form or fashion, most of them are already starting to include it, at least on their websites. If you log in as a participant, generally somewhere you're going to find some sort of a projection that says if you continue saving at your current rate by your retirement date, you should have lifetime income of X per month or X per year. Well, that's what this is all about. It's been a way to try to encourage participants to take an interest in what's this plan really going to be worth to me once I get retirement age? How much am I really going to be able to take out? So, a couple of key things here. The Department of Labor is under direction as part of the rule. They're required to issue model disclosures, model annuity assumptions, and other regulatory guidance by December 20th of this year. So as we sit here and look at the screen today, this is all we know. We don't know what they're really going to require. We don't know what the disclosures are really going to look like. We can guess, and that's why I think we see a lot of the record-keeping platforms already starting to try to implement some things, especially on their websites, is to try to start getting their feet wet in this, knowing that at least if they've done that, they can come along and tweak it based on the guidance. But here's the caveat. Protection from ERISA liability, so you as a plan sponsor get protection from ERISA liability if the plan fiduciaries use the DOL's model disclosures and model assumptions. We don't have those yet. So we're going to have to wait until they provide all those disclosures and assumptions, assuming they do it in December. And then all the record keepers, third-party administrators, advisors, folks like myself are going to have to look at those models and the guidance and try to wrap our arms around it and say, what's really required here? And I think what you'll see is that probably by a year from now, we're going to know. Now it says effective for statements furnished more than 12 months after the DOL has finished issuing all these assumptions and guidance. So really, what we're looking at is around the end of 2021 when we're going to start to see this officially start showing up on statements. It doesn't count if it's just on the website, at least what we're led to believe now. It'll have to be printed on at least one statement per year. And I think it's a pretty good guess. It's probably going to be the year-end statement, but nobody knows yet. Increased portability of those lifetime investments. So a lifetime income type of investment we can presume will be an annuity or an annuity type of investment, because that's what's generally used to derive a lifetime income calculation. Maybe that's not the case. Maybe they're going to cook up something new that we haven't seen before. But from my chair where I sit, I assume that it's actually going to be based on including an annuity type investment product inside a retirement plan. So in order for a plan to have a distribution that can be portable where a participant can move it, it would be allowed only if that lifetime income investment is eliminated as an investment option. So in other words, you got a participant here and there's a lifetime income investment option, and now you decide to take that out of your plan. You're not going to offer it anymore. That would allow your participants to take a distribution out of it without regard to any prior distribution restrictions. That would be an event that would allow them to take that out of the plan. If you get rid of it, you remove it from the plan. Or if the distribution, I should say, and if the distribution is either a direct rollover to an IRA or other eligible retirement plan. So my interpretation of this is that once you've got that lifetime income type of investment strategy in the plan, that it takes either somebody has to reach retirement age and activate it, or have choices at retirement age, which might allow them to roll it over or to take a distribution in a window of time. But otherwise, if they're still active in the plan, the only way they're going to be able to get it out is if you eliminate that as an investment option and they choose to handle it as a rollover to an IRA or another plan. Again, I could be off on this because this is really all I know at this point. But we're expecting a lot of guidance on this by around the end of December. And keep in mind too, they say this is only applicable for distributions during a 90-day period before the date that income option is eliminated. We interpret that also to mean maybe it's 90 days prior to the time they would flip the switch to turn it on if they were retirement age. But we don't know that. This is some speculation. So those are things to be on the lookout for in December when they come down with all those additional rules and guidance. Fiduciary safe harbor for selecting annuity providers. So they're going to offer liability protection for defined contribution plan fiduciaries, i.e. trustees, business owners who offer plans, for selecting insurers for guaranteed income retirement income contracts, as long as you follow their rules. So the protection includes the insurer's inability to meet a future obligation. In other words, if you use a certain annuity or insurance carrier to provide that lifetime income benefit in your plan, for you to have liability protection, the insurer has to be unable to meet its obligations, and you have to have followed the DOL procedures for determining who you used, for making that selection of what insurer or annuity company. And so they lay it out here in kind of generalized terms. You have to have an objective, thorough analytical search, look at the financial strength of the company, review costs, not necessarily pick the lowest cost provider, and you may rely on representations from insurers regarding their ability to fulfill on contracts. But this should eliminate some roadblocks to offering lifetime income options. In other words, if you follow the DOL's guidance, once that final guidance and everything comes out, and you pick a provider and you put this process in place to select your provider, so you follow their selection process, now you've done it. This should help protect you if that annuity contract or provider should go bad, if they should run into financial problems and not be able to meet their obligations. And also, because of that, the comfort level of giving you fiduciary protection should help eliminate some roadblocks to some employers who would otherwise like to sponsor a plan that has these options in it. Effective at the date of enactment, so this is really already in effect. But again, there's not much you can do about it until we have guidance from the Department of Labor and more from the IRS as well. There are some plan administration changes as a result of the Secure Act. We want to look at some of those. So one of them is penalty-free withdrawal for birth or adoption expenses. So it's a new exemption from the 10% early withdrawal penalty rule for DC plans, defined contribution plans, and for IRA distributions taken prior to age 59 and a half. So you haven't reached that 59 and a half threshold yet, so you're still subject to the 10% penalty for most distributions. Well, now you're going to be able to be exempt from that 10% distribution if you take money out to cover the cost of childbirth or adoption expenses up to $5,000. But to qualify, that distribution has to occur during the 1-year period, beginning the date when the child was either born or the legal adoption was finalized, and clock ticks 1 year forward from that. There's going to be, they say, a 1-year window. And if you do this during the 1-year window, take the distribution, this will apply. But keep in mind, it's expenses up to $5,000. Also does not apply to the adoption of a stepchild. So maybe in your marriage and your family relationship, you already have a stepchild, and you decide, well, hey, I'll adopt my stepchild, was going to do it anyway or whatever. Doesn't matter. Doesn't apply to adoption of a stepchild. Only a new adoption. And then, subject to certain restrictions, also allows for repayment of such expenses to a plan or IRA, meaning that in theory, when they come out with more guidance, you may also be able to put that money back into the plan. So right now, it would be treated really kind of like a hardship distribution, where you would get to take the money out, pay taxes on it, but not pay the penalty. Well, we think because of this, of where they say that you can possibly repay the plan or the IRA, that maybe they're going to allow you to put money back, to put that money back that you took out, which means you'd also probably, and this is an assumption, probably be able to get a tax credit back because you redeposited the money back into the account. So probably get a tax credit back on the taxes paid. Those are assumptions, folks. We don't know that. We're reading between the lines and trying to make heads and tails out of this, but it's certainly something that if it applies to you, it's worth keeping an eye out for additional guidance to see how they're going to handle that. So combined annual report, DC plans are going to be able to file a consolidated 5,500 for similar plans. This is really kind of a narrow area, but if it's defined contribution plans that have the same trustee, fiduciary or named fiduciaries under ERISA, same plan administrator, same plan year, same investments. So in most of those cases, they'd already be filing together anyway, like a 401k and a profit sharing plan. So we're still looking for more guidance as to how broad they may cast the net on this. But they say this new rule is going to be implemented no later than January 1, 2022 and apply to returns and reports for plan years beginning after December 30th, 2021. So it's really going to be something that kicks in 2022, and we know there's going to be a whole lot more guidance on this issue before the time comes. Best thing to do is to have a relationship with your third-party administrator for your plan or your actuary on a defined benefit plan. But for this specific purpose, for DC plans, is to have a relationship with your third-party administrator and to tell them, hey, when this happens, let me know if it affects me. For most people, it probably doesn't, because you have one plan or you have like a combined 401k profit sharing plan as it is, and you're already filing 15500. So we don't expect it's going to affect that many people. Increased penalty amounts. This is kind of a big deal. So penalties for failing to file certain returns, statements, notices. Think of this as, say, the Form 5500 that has to be filed every year on retirement plans, on defined contribution 401k type plans, profit sharing plans, DB plans, cash balance plans. That 5500 has to be filed every year. And so for late filings of those that occur after December 31, 2019, so this is already in effect, the penalties are going to go up. Now, it's not uncommon for small business owners to extend the filing deadline. Normally, the filing deadline, if you operate on a calendar year, the filing deadline is July 31st to file the 5500. And your 401k, your TPA, or your actuary would typically provide that, would prepare it for you and you sign off on it and file it. However, you can extend it to the extension deadline, the tax extension deadline. And so what we know, it's not uncommon for small businesses to extend that 5,500 filing because maybe they've extended their taxes, they still haven't decided, am I going to make that discretionary profit sharing contribution or not? And if I do, how much? So there's a valid reason for extending the 5,500 because you haven't yet made the decision about the numbers that are going to go in that 5,500. The problem is if you don't file the extension and you file the 5,500 late, or you file the extension and you miss the extension deadline. So the penalty for those late filings will increase to $250 a day and can go as high as $150,000 total. That's a huge increase over what it was under the old rule. Failure to file a registration statement, a daily penalty of $10 per participant per day, up to a total of $50,000 for that penalty. Penalty for filing or failing rather to file a required notification of change will increase to $10 per day, and the maximum's $10,000. And then the failure to provide a required withholding notice would trigger a penalty of $100 for each failure, with a limit of $50,000 for all failures during a calendar year. The big one though is this first one, really the first two, is if you don't file on time or if you fail to file a registration statement on your account, you're looking at big penalties. Don't be late. Don't be late. The key is have a good working relationship with your third-party administrator or your actuary on a defined benefit plan. And when they send you emails and tell you it's time to file this or we need X information to prepare to file it, be responsive. It's a big deal. Credit card prohibition really doesn't apply to many plans that I can even think of, but a plan cannot provide participant loans via credit cards or similar arrangements after the date of enactment. Again, shouldn't have much impact because very few people use credit cards for loans anyway. Reduced minimum age for in-service withdrawals. So minimum age for in-service withdrawals from pension plans like defined benefit, cash balance plans, money purchase, governmental 457B plans, etc. Used to be higher, and some of the in-service distribution was dictated by plan document and your specific plan design, but now the minimum age across the platform for all those DB type plans has been reduced to 59.5. And that consistency is really going to be helpful, I'll tell you that much. Under prior rules, in-service distribution withdrawals were not permitted until age 62, or in the case of government plans, 70.5. So they're anticipating more people who are going to be still working, so they're not retired, to be able to access their funds that they have saved into the plan. So they're going to be still working, still fall under in-service rules, but be able to access them sooner, which is probably going to provide some participants more flexibility to work half-time or whatever when they get to that age. Specific provision, it was part of the year-end appropriations bill, so point out that was not part of the Secure Act, but it figures in with all the other Secure Act related legislation. Should provide more flexibility and administrative simplicity because it more comes into line with 401 and 403B plans, 403B and 401K. And this is already in effect. It kicked in on December 31 of 2019. And then relief for DB plans that were partially frozen. This is a special rule, and it's it will make your head go back and forth like this if you try to figure out what it means. So if you don't have a DB plan that was frozen prior to April 5, 2017, you probably want to ignore this screen. What I'll tell you is that the relief for anyone who might fit the criteria here if you partially froze your plan and you meet certain requirements, and it's more requirements than what we could list here, and it's been frozen over time, you might have ended up with a concentration of highly comped employees who are still in the plan accruing benefits. Now, why is that? Let's say you froze your plan 4 or 5 years ago, and you have the pool of people who were in it at the time it froze, the employees that had to be covered under the rule at the time it closed. What we see is most employers set up DB plans to provide an additional layer of benefits for themselves, but they have to include non-highly compensated employees in the plan as well, okay? Under the rules, have to include a certain number of non-highly comp. But what we think is the problem is that over time, most of the attrition occurs with the non-highly comp people. And what happens is, as non-highly comp people either leave or they become highly compensated, it causes the ratio of highly comp to non-highly comp to be thrown off in the plan, to where the concentration of highly comped employees grows, the concentration of non-highly comp employees shrinks, and it causes problems for a plan. So that's what this whole piece is about. That's all I'm going to say on it, except to point you down here to where I put this in red. If you are a business or an entity and you sponsor a DB plan, and if you think this applies to you, your plan was frozen for years after December 31 of 2013. That's not a typo. It was frozen after that and before April 5 of 2017. If that's your case, don't ask me or someone else or try to Google to get information about it. Go to your actuary for your plan and see if they can use this new rule to help you out, to get some relief from having the situation where your plan could be becoming too concentrated and highly comped, and it's running the accrual amounts up. Go to your actuary to get help, okay? That's my very strong opinion. Go to your actuary to get help. Okay, employer incentives. Few things, and I'll try to rush through these. We're almost to the end. Goal from a lot of this legislation is to increase participation in plans. So one of the things that the government is offering is tax credits. So a tax credit of $500 for a startup plan increased to as much as $5,000 per year per 3 years, or equal to 50% of the startup costs, up to a minimum of either $500 or $250 multiplied by a number of highly comped employees, who non-highly comped rather, who participate in the new plan, capped at $5,000. So it doesn't mean everyone who does this is going to get a credit for $5,000. You can get the credit of $500 per year for 3 years, or $250 multiplied by the number of non-highly comped eligible employees who participate in the plan. And it's capped at $5,000. $5,000 is the max on the credit. So it doesn't mean that just because you start a plan, you're going to get $5,000. You're going to have to read the either or part of this. And the best thing to do in a case like that is to get your third-party administrator to help you come up with what is the exact number of people who are going to count if you do this, the number of people who are actually going to count toward that, and then do the calculation or talk to your CPA and use that number as the derivative for how you're going to calculate the tax credit. There's also a new $500 tax credit per year for 3 years for small employers who add an automatic enrollment arrangement to the plan. That means when it comes time for your employees to join the plan, they automatically get enrolled unless they actively decline. And there are always, with any provider, there are going to be procedures for how they would actively decline. but you can get that $500 per year tax credit by adding that feature to your plan. That's again available starting in this plan year we're currently in. Extra time to adopt a plan. This is another kind of a big deal. You can adopt new stock bonus or other types of pension plans. The rule on how far into the tax year you can go before you adopt them has been changed. Previously, there were only certain things you could adopt in arrears, okay? But now they've expanded this to include stock bonus plans, ESOPs, pension plans, profit sharing, annuity plans, profit sharing. Get asked this all the time. Normally, you had to set a profit sharing plan up by December 31 of the calendar year, tax year, when you wanted that plan to be able to apply in arrears. So you had to make a decision by December 31 if this was going to be a year when you were going to have a profit sharing plan. But now, these different kinds of plans, you can wait until after the beginning of the new year, all the way up to your tax filing deadline to make that choice. Now, you can't wait till the tax filing deadline to decide and then say, oh, by the way, I've still got to set up the plan. The plan has to be set up and ready to receive funds by then. But you get to make that choice in arrears, much like you used to could do with, or you still can do with a SEP IRA, is wait and do it after the fact retroactively. There's a catch, one big catch. I put it in red down here. 401k, salary deferral contributions can only be made on a prospective basis, meaning going forward. So you can set up a profit sharing plan next spring and have it apply to 2020 and fund it for 2020 in arrears. But you can't set up a 401k plan after the fact. You have to set up a 401k plan and then give your participants an actual opportunity to start contributing at the time the 401k kicks in. Final poll question. Which of the following reasons might entice your business or organization to consider making changes to your current plan design?
Jeff, if you want to continue talking while we get those results, that's fine.
Okay, I'll click forward. There are some other impacts, and so I'm going to move the poll over on my own screen so I can see it. So Secure Act amendments are due the last day of the plan year, first of the plan year, beginning on or after January 1, 2022. Okay, so it sounds all convoluted, but the amendment has to be put in place for any plan year beginning on or after January 1 of 2022. Best thing to do is talk to your TPA and ask them about the pieces you're interested in and what do we have to do to amend the plan. Secure Act also applies to 529 plans, spends the meaning of qualified expenses to include student loans and apprenticeships. Beyond that, I just have a final thought, which is, as with any new legislation, and you've heard me mention it several times today, we're still waiting for guidance, we're waiting for forms, we're waiting for processes and for model strategies that they expect plan sponsors to adopt. And most of that we don't have. We're not going to have it probably for a few months. So the gray areas continue. The thing you should do is, if any of this catches your attention, you think it either applies to you or you want it to apply to you, talk to your third-party administrator or your actuary. If you've got a DB plan, you're going to talk to your actuary. If you've got a defined contribution plan like a 401k profit sharing plan, talk to your TPA. Ask them, how does this specific provision that I'm interested in, how does this affect me and how do I use it? By when, and what do I have to do to set it up and include it in my plan? That's the best way to make sure you know how it affects you, rather than taking for granted what you might see on the internet. And that kind of wraps it up. I appreciate everyone's time today. And Amy, I think we're out of time, aren't we?
We are, but here are the results real quick of the last poll.
Okay. So of the things that might entice folks to consider changing the plan design to provide better benefits to everyone for the purpose of recruiting and retention, that's number one. And of course, second's to make the plan more tax efficient and cost effective. And what I can tell you from my own experiences, those are always the top two considerations for plan sponsors. I hear that over and over again. Tax value, cost effectiveness, and then how do I use my plan to get the best people and keep them in my organization. I appreciate everyone's time today.
Yes, thank you all so much for attending, and thank you to Jeff for presenting. And we hope that everyone has a great day.
Thanks a bunch.